A very good evening to all of you, friends. A very good evening to all of you. Welcome to BYJU'S exam prep and welcome to this 100 most expected SLAT questions for 2024. In this session, friends, I shall be discussing with you certain very important principle and fact-based questions. So in this session, the questions that you will get to solve are all principle and fact-based question. That means there will be a principle that will be provided to you. Understand the principle, understand what it means. Then you have to apply those principles on the facts, right? So you have to apply those principles, those laws into the facts, understand the application of the principles in the fact, and there will be 4 options. You just have to solve those questions, which are multiple choice questions. So 4 options per question. We have 6, 7 around those type of questions today to solve. So guys, let's get started. But before we begin, BYJU'S Exam Prep brings to you a SLAT with BYJU'S Exam Prep. Unlock your 3-day free trial access to all our courses. Link is provided in the description box below. Go there and just click on that link. BYJU'S Exam Prep brings to you CLAT 2025 comprehensive course. 380 plus hours of live classes, recorded videos, video solutions of the mock test, topic-wise practice question, then sectional practice test, study material, doubt resolution, and the CLAT Ignite magazine. The first question is up there on your screen. Read the principle very carefully. Now, the principle over here says that nothing is an offense if it is committed by a child below the age of 7 years. So 7 years. So if a child commits an offense, which generally is an offense under the IPC or the criminal law, now nothing will be an offense if his or her age happens to be less than 7. Tarun, a aged 5 years, placed a drawing compass on the bench, which was pointed, when his classmate Ankur stood up for a stretch. Ankur gets hurt while he is sitting on the compass. So this is a little naughty boy who is just playing with his drawing compass, keeps the compass on the bench where Ankur is going to sit, because he just stands inside the class. So he just stood inside the class for some reason. He's trying to sit down and he is injured owing to his sitting on the compass. Ankur's father wants to file a criminal case against Tarun. Now, what is Tarun's age? 5 years. So 5 years. A child. Nothing is an offense. He will succeed? No. He will succeed? No. He will not succeed? Correct. As Tarun and Ankur are classmates? No, I want some option which is closer to 7 years or 5 years. Okay, he will not succeed? Correct. As nothing is an offense committed by a child below the age of 7 years. Now, here the principle. Now, both option C and option D are correct. If you see this part, just this part, both the things are correct, C and D. But the reason given, which is linked to the principle, which is aligned to the principle, is option D. And henceforth, we are going to choose option D. Is that clear? Is that clear to everyone? Okay. So option D happens to be the correct answer. Okay. So for SLAT, you are going to get these type of question. These are not very difficult question, but you just need to read the principle, apply the principle on the facts, and choose the correct option. Question number 2 is up there on your screen. Let's read it together. Whosoever brings in any manner entrusted with property or with any domination or over property dishonestly misappropriates, very very important, or converts to his own use of that property dishonestly, uses or disposes that property in violation of any direction of law prescribing the mode in which such trust is to be discharged, or of any legal contract, expressed or implied, which he has made touching the discharge of such trust, or willfully suffers any other person to do so, commits criminal breach of trust. So the principle or the meaning of criminal breach of trust is provided. Is that clear? So whosoever in any manner entrusted with a property, if you are entrusted with a property and you dishonestly misappropriates or converts that property for your own use, or do something in violation of any direction of a court or by law which is entrusted on you under a legal contract, you commit criminal breach of trust. Okay? Aman, a revenue officer, is entrusted with public money. Okay? Is it Aman's money? No, it is public money. He is just given to for safekeeping and is bound by an express contract with the government to pay into a certain treasury all of public money which he holds. So, under a contract, he is supposed to deposit that money, not his money. It's a revenue officer. It's public money. He is supposed to entrust that money, okay, under a contract to the treasury with the government. Aman dishonestly, very very important, the word over here, please come over here, dishonestly is mentioned. Dishonestly, line 2 over here, line 2, okay, dishonestly is mentioned. Dishonestly appropriates the money. So he, other than by virtue of the contract, he was supposed to entrust that money with the treasury. He does not. He misappropriates. Let's see the correct answer. Aman has committed the offense of criminal breach of trust. Okay, good. Aman has not committed. Aman has not committed. Aman has not committed. I do not have to read this part. I do not have to read this part because I am convinced by the facts. Let's go to the facts. Aman is a revenue officer who is entrusted with some public money. He has to pay that certain money to the treasury. He misappropriates it dishonestly. What more? So, Aman has committed the offense of criminal breach of trust. Is that clear? Everyone? Okay? Is that clear? So, there is an express contract between Aman and the government that whatever public money he holds, he has to deposit with the treasury. He does not do it. So, see how you can solve these questions accurately. Go to the next question. Question number 3. Let's read it. Whosoever takes or entices any minor under 16 years of age, if it's male, 16 years of age for male and 18 years of age for woman, or any person of unsound mind, out of the keeping of the lawful guardian of such minor or person of unsound mind, without the consent of the guardian, is said to have committed kidnapping. So, kidnapping means if you are enticing a minor. Enticing means किसी को लालच दिखाना, एक 5 साल का बच्चा है, उसको आपने डेयरी मिल्क दिखाया, वो आपके पास आ गया। एक 17 साल का लड़का नहीं करेगा, या कोई एक 18 साल की लड़की नहीं करेगी। सो प्लीज ट्राई टू अंडरस्टैंड। लेट्स कम टू प्रिंसिपल नंबर 2। Whosoever by force, very very important, now we are talking about abduction, or by any deceitful means induces any person to go from any place is said to abduct that person. So the difference between kidnapping and abduction is provided. Minors, male के लिए 16 years, woman के लिए 18 years, person of unsound mind. You are taking that person out of the keeping of the lawful guardian. Is that clear? That is kidnapping. You are not using force. Whereas in abduction, the principle very clearly says that there is an application of force. Let's come to the facts. Sylvia, a 21-year-old girl, 21-year-old girl. So, whosoever takes or entices a minor, 16 years for male, 18 years for female. So, principle number 1 goes, got admitted to a post-graduation program of a reputed university. Then she became friendly with one of the boys, Solomon. Solomon proposed Salvia, but she refused and stated that they are just good friends. At college freshers, Solomon threatened Salvia on gunpoint. Yes, I was wanting this word. Gunpoint. So you are threatening using force. How? You might not be slapping her, but you are using force like putting a gun on the on someone's forehead. Go from the college freshers to a cinema hall. Use of force is there. Whosoever, principle number 2, whosoever by force compels. Let's see what's the correct answer. Solomon has committed the offense of kidnapping. No. Solomon has committed the offense of abduction. Solomon has committed the offense of kidnapping along with abduction. No. No kidnapping, none of the above. No. Option B is the correct answer. Is that clear? This is how you should be understanding the facts, understanding the principles and all. Is that clear? Is that clear? Okay. Very good. Very good. Very good. Anshuman Singh, yeah, we will have a session very soon on the difference between culpable homicide and murder. You can check on our channel itself, on our YouTube channel itself, wherein I have in a number of sessions, I think I have discussed. Just type BYJU'S exam prep and CLAT and culpable homicide plus murder. So you'll find the link over there. Ayushman Singh. Okay. Okay. Fantastic. Chalo, let's move on to the next question. Question number 4. Principle. Will you read it or do I explain to you like I was explaining to you for the first 3 questions? Consent is to be free without coercion. What is the meaning of coercion? Committing or threatening to commit a forbidden, which is forbidden by the Indian Penal Code, unlawfully detaining, threatening to detain any property or to the prejudice of any person, whatever, with the intention of causing any person to enter into an agreement. So if you are threatening someone and forcing someone to enter into an agreement, that is called coercion, and coercion is said to be free when it is not under, consent is said to be free when it is not caused under coercion. Okay. And principle 3, it is immaterial whether IPC or not in force in a place where the coercion is employed. Let's read the facts. Harry, on board an English ship on the high seas, causes Rahul to enter into an agreement by an act amounting to criminal intimidation under the IPC. So Harry forces Rahul to enter into an agreement by using criminal intimidation. Rahul afterwards sues Harry for breach of contract at Calcutta. Decide the validity of the agreement. Now, principle number 3. It is immaterial whether the IPC or not is in force in the place where the coercion has taken place. It has taken place in the high seas. Do remember that? Let's see the question. Yes. The agreement is valid as IPC is not applicable in the high seas. No, because of principle number 3. The agreement is void ab initio. No. See, consent, okay, coercion, undue influence, mistake, right? Fraud. Now, these are not void. You have to go to the court and say that the consent that I have given to this agreement has been influenced under coercion, is influenced under undue influence, fraud, misrepresentation. You have to go and tell the court. So it is not void ab initio. It is not void ab initio. Please remember this. It is voidable. So here option B also goes away. The agreement is voidable at the instance of Rahul because he was coerced. The agreement is voidable in the instance of Harry. Harry has committed a wrong, criminal intimidation. So how can he go to the court? It's illogical. Harry himself has committed criminal intimidation. So how can he go to the court and make the agreement void or voidable? No, he does not have that authority. Only Rahul has it. Is that clear? I hope you understood it. Okay. Because Rahul's consent was obtained under coercion. Very simple. I hope you guys are enjoying this session. Friends. Okay. Fantastic. Great. Fantastic. So if you're liking this session, do press the like button. Friends. Okay. And share this session. Question number 5. Let's read the principle. There are 2 principles provided. When at the desire of the promisor, the promisee, or any other person has done or abstained from doing, does or abstains from doing, or promises to do or abstain from doing something, or abstinence or promise is called consideration. So, consideration is the price that the acceptor. Now, let me explain to you. I say I want to sell my pen to you for ₹100. So, I am the offerer. I am offering you. You happen to be the acceptor. Now, you have to do something or abstain from doing something for me to give you the pen. So, what is that thing? That is ₹100 that you have to give it to me. Is that clear? An agreement made without consideration is void. Okay. Amit orally promises his son, Puneet, to gift him a car on his 18th birthday. At Puneet's 18th birthday, Amit refused to give the car. Puneet files a suit for the breach of contract. Now, was there any intention? Was there any intention between the parties that in case one party fails to fulfill the promise, the other party will go to the court? Now, these are all domestic contracts or social contracts. Now, what are these? These are, I say, Mr. A tells his son that when I come back from office, I will get you a dairy milk. And he forgets. So can the son go to the court and say that, my father has failed to fulfill his promise. I need compensation. No. There was no intention to enter into a contract. There was no intention to enter into a contract. Okay, so let's see the correct answer. Amit is bound to give the car. Amit is bound to give the car. Amit is not bound to give the car. None of the above. Okay, not bound, not bound. Only option C is the correct answer. See, आपको प्रिंसिपल पढ़ना है और फैक्ट्स को देखना है प्रॉपरली, अंडरस्टैंड करना है फैक्ट्स को. तो बेस्ड ऑन द प्रिंसिपल आपको आसानी से आंसर मिल जाएगा. Is that clear? Okay. Our next question. Let's read the principle. Defamation is the publication of a statement which tends to lower the reputation of a person in the estimation of other members of the society. So what is defamation? If you are lowering someone's reputation in the eyes of third party. Now facts. Taran and Brooke, both professors in the college, had an argument over parking space. You know, parking space is a problem across India. Taran supervises and runs the college magazine. And he mentioned an article stating that Brooke is a man of weak character. So what he does, he mentions this in an article in the magazine, college magazine, and is involved in an illicit relationship, which is not true. Now, Mr. A and B had a fight over certain parking space. And you write an article in a newspaper, in a college magazine, and you say that, the other guy is very weak character, he is involved in illicit relationship, but which is not true. Just make false allegation, decide. Tarun has not committed the offense of defamation. Tarun has committed moral wrong. Oh, no, there is nothing called moral wrong. Taran has committed the offense of defamation. Okay. Taran has neither committed defamation nor moral. Nothing about moral thing. Option C is the correct answer. There is no doubt. Are you guys understanding how to solve these questions? So this is how you are going to solve these questions, friends. This is how you are going to solve these questions. Because these questions are examples of the kind of questions which you will be getting in your examination. Is that clear? Is that clear to everyone? Okay. ज़्यादा प्रेशर मत लीजिए, क्योंकि अभी आप जैसे क्वेश्चंस हम लोग जैसे ट्राई करवा रहे हैं वैसे ही क्वेश्चंस आपको मिलेगा. So kickstart your other law entrance test preparation. That's also there. We are having separate batches for OLET preparation. CLAT 2025 students, join our comprehensive course. We are providing you with 380 plus hours of live classes, recorded videos, video solutions of mocks, practice questions, practice test, study material, doubt resolution, and the CLAT Ignite magazine. For those of you who are interested in just the mocks, yes, we are providing you with 24 CLAT mock, 15 ALET mock, and 15 OLET mock. Okay? Get started, friends. Get started. So before saying goodbye, I want all of you to subscribe to our YouTube channel, follow us on our Instagram, like our Facebook page, join our Telegram channel, and do not forget to download the BYJU'S Exam Prep app today. With this, we come to the end of this session. Thank you very much. God bless you. Stay home, stay safe, stay healthy. Bye-bye. Take care. All the best.